Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers. For today's episode 58, we're going to look at some unknown issues that you need to address in order to avoid state income taxation of trusts. In particular, we're going to dive into a U.S. Supreme Court case from about a year and a half ago. I can't really pronounce this name well. It's Kaestner or Kaestner. I've never really heard it pronounced in a lecture that I remember. But name aside, there are some important takeaways in this discussion if you're dealing with any sort of type of trust where you have a trust administered in one state and a beneficiary living in another state. Now, as always, this presentation is not intended to substitute for legal or tax advice. So, what was the Kaestner case all about? Well, this was a situation where there was a New York trust, and one share of that was created for Kimberly Kaestner and for her children. And she and her children moved to North Carolina and lived there for a time. And while they were living there, she never received any distributions from this trust, of the income at the very least. But what the North Carolina Department of Revenue tried to assert is that based on the mere fact that she was domiciled in North Carolina, trust distributions were irrelevant, and instead North Carolina had the right to tax the income of any trust that was being held for the benefit of a beneficiary in North Carolina, even if that trust was administered in another state. And this went all the way up to the U.S. Supreme Court, and the U.S. Supreme Court said no, but beyond that, really all we had to go off of in this case were very good facts. So this presentation is all about those facts. What are some pitfalls and situations you need to keep in mind in order to avoid a high tax state where maybe a beneficiary lives from taxing income maybe of a trust that's established in a low tax state? So you're going to see me use those terms high tax state and low tax state throughout. So first off, we're going to look at the administration of the trust. So obviously you want to avoid that the trust itself is not administered in the high tax state. So to help, you need to make sure that there's a trustee that's in the low tax state and that keeps its principal place of business or domicile in the low tax state as well. Now, if you're choosing somebody like a bank trustee, that seems like a safe choice, but it might also be a dangerous choice because one of the facts in this case was that it helps for the trustee not to have a presence in the high tax state. So for example, if you use a large bank that has branches in all 50 states or a number of states, they may be a bad choice of trustee if you're trying to avoid this issue. And there's a weird fact here that the original trust documents and records shouldn't be kept in the high tax state. Now obviously the beneficiary can have a copy, but it's really a matter of does the beneficiary have the original, and if not, then that is a helpful fact. And then finally, records such as accountings should be generated in the low tax state and then sent to the beneficiary in the high tax state instead of being generated in the high tax state itself. Then it might also help if you have options to name trust protectors or trust advisors to avoid naming a trust protector or a trust advisor who's domiciled or has a primary place of business in the high tax state as well. Now, for investment advisors, it's important to note that custody of assets should be in the low tax state and not the high tax state. So this tends to favor the use of independent advisors with no presence in the high tax state for the same reason as I mentioned with a trustee. If you have somebody like a wirehouse or broker dealer with multiple branches, then that might allow a state Department of Revenue to say, hey, for example, maybe Raymond James does business in this state, or Morgan Stanley does, we should. So because of that, that investment advisor should be treated as if they're managing assets here, even though the advisor themselves may be officed in a low tax state. Now, obviously, if you look at the custodian of assets, on the RIA level, obviously if a custodian platform like Schwab or Fidelity is being used, that may not be sufficient to establish ties to the high tax state, but it's still a situation to keep in mind. You also want to check the investment mix just to make sure there's no direct investments in the high tax state, such as stock in a corporation that's headquartered in the high tax state, or maybe investment in something like a QOZ, or even real estate in the high tax state. Or a municipal bond issued by the high tax state, even though it's a tax-free return, that's still a direct investment in that high tax state. Then finally, real estate or personal property, you want to avoid owning that if it's in the high tax state. Next, with the distribution of the trust, you need to look at whether any income is actually distributed to the beneficiary. If so, obviously that income could be taxed in that high tax state, but if there's income held in the trust, that's what we're really concerned with here. Can that undistributed income be taxed? So could the beneficiary demand a distribution as trustee or under a demand right? If so, that could be a sufficient tie to tax that income. So it helps if the trust is fully discretionary and doesn't have, for example, an ascertainable standard that could be enforced by the beneficiary. And it's also helpful to look at, could income, instead of being distributed, be applied for the beneficiary's benefit in the low tax state? And maybe could you prefer distributions of principal before income? It might also help to dig into the high tax state's definition of income and also look at maybe the beneficiary receiving loans from the trust instead of income distributions. And then finally, with respect to the beneficiary control itself over the trust and distributions maybe to other beneficiaries, you might want to avoid having the beneficiary be the trustee or have a power to name a trustee in the high tax state. You might also want to avoid, this was a fact from the case, you want to avoid frequent in-person meetings between the beneficiary and trustee in the high tax state. You might also want to dig into the beneficiary's power to name a trustee or trust protector or trust advisor and make sure they couldn't name one in the high tax state. And then look at a beneficiary's power to direct trust investments or name an investment advisor and make sure that that investment advisor would act in a low tax state and not in the high tax state. And then finally, even if the beneficiary has an enforceable right to income or grantor trust power, it's important to note that if the beneficiary releases that power, the beneficiary could still be treated as the grantor of the trust. That power is in particular called a 678 power. So if that happens and the beneficiary is treated as the grantor, that's probably the lowest hanging fruit for any state to try to claim the right to tax that undistributed income in the trust. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to this episode of The 10th of an Hour, and I look forward to seeing you in the next one.